as soon as you see him, would you agree that your words to him were, "What's going on? Come here." He's not free to leave at that point, right?
In circumstances, I would say yes.
When they say, "Hey, come here," that is a seizure for Fourth Amendment purposes.
Well, I think we all agree that was a seizure. I'm going to bind over on count 3 only.
What you just watched is every Fourth Amendment case distilled to its purest form. A cop, a suspect, 2 words. Philip Lloyd was sitting outside a Citgo at 1 a.m. when a 4-month rookie cop said 2 words to him. "Come here." Lloyd complied, and in the process got a crash course on the differences between a consensual encounter, a Terry stop, and a full-blown arrest. Lloyd hit the jackpot. Defense counsel makes the argument that right at that moment, the officer had no information tying Lloyd to any crime, and Judge Oakley thoroughly agreed. So then why did Judge Oakley bind it over for trial? Let's roll, Nurse.
Why were you at the Citgo gas station?
The gas station clerk called us there for a person harassing.
You object at this point to any statements made by Citgo gas clerk.
Set out for the truth of the matter asserted. She could be the biggest liar. She could be Pinocchio. Fact is, the employee is giving the police officer information, whether it's true or false. He can act on it. So Senator 6, set out for the truth of the matter asserted.
Well, I'm not even sure that a foundation is in play. The statement was made to Officer Suppression, or that Officer Suppression heard the content of the statement.
And that's because there was an interjection before that's
I'll let you lay foundation.
Speak at the gas station.
It was a dispatch call from dispatch.
Did you receive the dispatch or was it another officer?
The dispatcher received the call and they put it on the radio to my unit.
Did you talk to the dispatcher?
Over the radio, yes.
So what information were you given about the Citgo gas station?
The gas station had been called referencing a blackmail alert.
Again, I'm going to object. So now we're into double hearsay. We're into
Or not hearsay at all if it's not introduced for the truth of the matter asserted, which it's not. It is introduced to establish why he went to the Citgo. So I'll overrule the objection. You're welcome.
Yeah, why did you go to the Citgo station?
We were dispatched to the gas station for a male harassing customer.
Were you given a description of him?
I was,
What description were you given?
it's in my report, if I could look at
With reviewing the report, refresh your memory.
it.
Officer, what description were you given?
I was advised there was a male wearing a black sweatshirt and black boots.
Did you notice anybody at the Citgo station matching that description?
Yes, sir.
How many people did you see at the Citgo gas station at 1 in the morning matching the description provided me by dispatch?
Just the one, sir.
And who was it?
Lloyd.
Did you learn from Mr. Lloyd his name? How did you gain Mr. Lloyd's name from Mr. Lloyd?
I asked him.
You asked him what?
I asked him for his ID. He advised he did not have one and identified himself by word of mouth.
Sir, do you eventually gain his name, though, Phil Lloyd?
Yes.
How do you gain that name?
He told me his name.
When he told you his name, what steps did you take, if any?
I wrote it down in the flowing search of Mr. Lloyd.
When you asked Mr. Lloyd his name, had you arrested him first?
No,
Had you handcuffed him?
no,
Had you placed him in custody?
no.
You threatened him in any way? Well, armed with the knowledge that you had a man named Philip Lloyd near you or with you, well, by the way, where is he at the gas station when you see him?
He is sitting on the walkway of the gas station
Outside or inside?
outside.
Armed with the information that this person might be Philip Lloyd, what steps do you take?
I conducted a lead search of the person named Philip Lloyd and confirmed that it was him with the photograph that lead/SOS provides and
SOS is what?
Secretary of State.
What did you conclude after reviewing the Secretary of State photo?
I found out that he had warrants for his arrest.
As a result of learning that Mr. Lloyd had warrants against him for his arrest, what did you do?
Placed him in handcuffs and arrested him.
Find any firearms? Where?
It was in his right sweatpants pocket.
What?
The revolver, the Smith & Wesson revolver.
What did you do with that weapon when you noticed that it was confiscated?
My partner took it to the rear of the patrol vehicle and made it safe.
What conclusion, if any, did you read about the state of sobriety of this defendant?
When we first approached him, I noticed he was unsteady, had an unsteady gait, and eventually needed a garbage can to steady his balance. And when approaching him, the odor of intoxicants was heavy, emanated from this person.
Can you estimate for Judge Oakley the number of drunk driving capers you've been involved in as a police officer?
Did you just say caper?
I did. That's a prize.
It worked.
Art events. Haven't you?
More than 5?
And what conclusion did you reach as to whether you're sober or innocent?
I saw he was not sober.
And as soon as you pull up, you and your partner hop out of the car,
Step out of the car.
step out of the car, and you immediately see the person later identified as Mr. Lloyd outside the gas station.
That's correct.
You never go in the gas station,
That's correct.
and there's no one else outside, right?
That's correct.
So you don't see him interacting with any other person.
At the time, that's correct.
You don't see him committing anything that would be called harassment.
That's correct.
And you don't observe any sort of, bulge consistent with a firearm at that time when you first see him, right?
That is correct.
And you see him, but you didn't recognize him from any prior interaction, no?
I did not recognize him.
Okay. And as soon as you see him, would you agree that your words to him were, "What's going on? Come here."
That sounds correct.
Yes. And so at that point, you've given him an official order to come towards you, right?
I would say so, yes.
Yes. He's not free to leave at that point, right?
In the circumstances, I would say yes.
Thank you. And this is at the point where you're giving him that order, you don't yet know this person's name, right?
Right.
You don't know anything about what he has warrants. So you don't know anything about intoxication.
Right.
Right.
So we can
And
follow.
when you say those words, "Hey, come here," his body at that moment, he was kind of walking away from the front door of the gas station. Would you agree?
That's correct.
Okay. Safe to say he was not approaching you when you made that order, right?
Correct.
Okay. But then as soon as you make that order, he submitted to your order and came to you and your partner, right?
Yes.
I think that the controlling case here would be the California versus Hood RAG case from the Supreme Court. That citation is 499 U.S. 621. That's a 1991 case written by Justice Scalia. And that's really the case that stands for the proposition that when does a seizure occur? If an officer has not used physical force on someone, if an officer gives an order that says, "Hey, you stop," and that person runs away, that person has not been seized for Fourth Amendment purposes. But if an officer gives an order that says, "Hey, you stop," and it's a lawful order, the person then submits to that show of authority, that is the moment of seizure for Fourth Amendment purposes. It's really a question of does this person feel free to leave in that situation? And we even had Officer Sakuna agreeing that once he's given a lawful order to Mr. Lloyd, that Mr. Lloyd is not free to leave. So let's think about what is known to the officer at the time when he gives that order, that seizure. He doesn't know Mr. Lloyd's name. He doesn't know anything about Mr. Lloyd having warrants. He sees Mr. Lloyd walking away from the scene. He doesn't observe Mr. Lloyd committing any crime. He doesn't observe Mr. Lloyd near anyone else He doesn't observe any of this harassment. He doesn't have any details about what might have occurred.
So I too am familiar with California versus RD. And in that case, there's a young man, a young male, the police see him, he sees them, and he runs away. This defendant runs away, and the police run after him. And the court says, there's no seizure. There's no seizure. He ran away. Now, in this case, I'd like you to imagine we live in a world where under these circumstances, an officer has to say, oh, I see this guy, he matches the description of somebody who allegedly was harassing people at the gas station, and I can't do anything about it. Hey, nice to see you, officer, nice uniform, have a good life. That's not the case. The police have a right to investigate. It's 1 a.m, there's a harassment call, there can only be one guy, he matches the description. If he can't say, oh, hey, come here, what's your name? I don't want to live in that world.
I just want to make sure I understand the argument, Mr. Martin. Because I think what your argument is that based on what they got from dispatch alone, they did not have enough to investigate the gentleman they saw outside the station.
If you think about, my argument is, when they say, hey, come here, that is a seizure for Fourth Amendment purposes.
I think we would all, I don't think you're disagreeing to that, are you? No. I think we all agree that was a seizure.
That's a seizure.
Yeah.
So what's the lowest standard in Fourth Amendment law?
Right.
Reasonable suspicion. So is there reasonable suspicion at that time? So if it's, and there's reasonable suspicion for Terry's purposes, that's armed and dangerous, I don't think that's met.
I would agree.
For reasonable suspicion also appears in the traffic stop context, reasonable suspicion of a traffic violation. That's obviously not present here. Reasonable suspicion of a crime, I don't think that's relevant either. And in fact, that's...
Hold on. Let me stop you there, because I think we all agree that's where we disagree. You think there was reasonable suspicion of a crime triggered at that point, you don't.
Piece of Michigan law that says that an officer may arrest when a felony or misdemeanor is committed in their presence, or if they have reason to believe that a misdemeanor of a certain severity was committed even outside of their presence. And under that law, I don't think that the standard is met here either.
I would agree with you. Yeah, I think the question is whether or not, based on the dispatch call only, they had a reasonable suspicion. Because you don't think they do without more investigation before they seize.
I agree. It'd be different if the dispatch call said he's intimidating other customers and making them feel unsafe. I mean, that might be reasonable suspicion of some sort of assault or threat, or he's been told to leave and he's not leaving. Reasonable suspicion of a trespass. But this scant amount of detail, so we're just not going off of enough here. And you're making someone feel not safe to leave. Well, just go into the gas station, talk to the clerk, learn some more information first. So then you're doing this investigation based on personal knowledge and not just stopping people on the street based on this extremely undetailed, unspecific report that you got through a dispatch.
It would mean they could not hold him, they couldn't ask him anything, they would have to go into the gas station and conduct an investigation, so to speak. Who called? What was it all about? In the meantime, guess what happens to the defendant? He's gone. He can run away under Mr. Martin's theory here. He doesn't have to stay. And we say, stay here, we're going to investigate what happened in the gas station. That would be a seizure. That's not what happened here. The fact is, then there would be misconduct on the part of the officer who say, hey, I'm leaving. I have other things to do. I want to stop at Dunkin' Donuts. That would be misconduct in office. He probably would lose his job if he just said, let it go. He has to investigate in the way he did. Hey, what's your name? How incriminating is what's your name? How many of us have outstanding warrants as this man did? He's the one with the warrants. He's the one who didn't show up in court. He's the one who the officer would have to arrest him.
All right. Thank you, gentlemen. All right. Thank you, gentlemen. I'm going to bind over on count 3 only. I understand your argument, Mr. Martin, that the dispatch call that there's a black male wearing a black hoodie and black pants that's been harassing customers is not enough detail, but I think it is enough detail for an investigation. And I don't think an investigation that starts with what's your name is onerous. So I'm gonna bind over only on count 3. I agree with your argument on the under the influence carrying a weapon. Any other clarification for the record?
No, thank you, Judge.
All right, so this is a motion to suppress Nataki Thomas for DUI and DUI less safe. So the court is ready. Mr. Owen Lynch is representing the defense.
Okay, so his device died.
We'd ask that the court grant the motion. The state was on notice that their devices needed to be charged.
Well, he was on here this entire time, though, but so his phone must have just died.
I know, I'm somewhat joking.
Amusingly denied, Mr. Lynch.
Officer Nathan Proctor,
Officer Proctor, where are you employed?
City of Riverdale Police.
And how long have you been employed with the City of Riverdale Police Department?
Just shy of 5 years.
What's your current role at the Riverdale Police Department?
Police Officer 2, Road Patrol.
And what are some of your duties?
Currently, right now, I'm assigned to the traffic unit, so responding to calls for service, traffic accidents, and general patrol, things of that nature.
And did you come in contact with the defendant?
I did.
And how did you come?
I'm going to object to the extent that it calls for hearsay.
How he came in contact calls for a hearsay?
Well, if he's going to testify as to what another officer reported to him or that he received a call that stated certain information, then the question would call for hearsay. So I just...
Well, since I haven't heard it yet, let me state that let him answer the question.
That is correct, Your Honor. I was called by another officer.
So you arrived to the scene and you spoke with, and who was the first person that you spoke with?
The deputy that called for the assistance.
Okay. And when you spoke with him, what did he advise you?
He explained that he had stopped the vehicle because that it had, he observed it leave its lane and then jerk back into the lane. He initiated the traffic stop, and when he walked up to the window to speak to the operator, that he smelled alcohol. Well, I started by asking her some medical questions, such as any recent head trauma. She normally wear glasses or eye contacts, things like that. And once I established that she would be eligible to take the test, I started with horizontal gaze nystagmus. I checked her eyes for equal tracking, pupil dilation, and from there I conducted the horizontal gaze nystagmus test. She showed 4 out of the 6 clues. And from there, I went to the one-leg stand where she was observed, instead of placing her foot in front of her, approximately 6 inches off the ground, she bent her knee back to have her foot behind her. And she was also observed putting her hands in her pockets, not keeping them at her side. And the walk and turn test, she missed some heel-to-toe steps and conducted an improper turn. And I'm going all by memory. I don't have report or the video right now.
I'm going to object at this point. This is not competent evidence. This is not scientifically validated evidence. I believe that what's admissible is whether she's positive for alcohol or not.
Well, he hasn't given a number, so I'm going to assume that he's testified enough to know he can't give a number.
I just, the phrasing of the question, Judge, but that's what I'm asking.
Go ahead.
The portable breath test did confirm the presence of alcohol.
I'm going to read the implied consent notice for suspects age 21 or older. The state of Georgia has conditioned your privilege to drive upon the highways of this state upon your submission minimum period of 1 year. Your refusal to submit to blood or urine testing may be offered into evidence against you at trial at your own expense and from qualified personnel of your own choosing. Will you submit to the state-administered chemical test of your blood? Is that what you read?
Yes.
Did, when you read that implied consent notice to the defendant, what was the response?
He agreed to provide a blood sample.
When you concluded your DUI investigation, what decision did you make?
On the scene, I effected an arrest and placed her in custody for DUI less safe.
And you placed her in custody based on a totality of circumstances, including your observations, the odor of alcohol, the defendant's performance on the standardized field sobriety testing and anything else?
No, I'm going from memory. I'm sorry. So I don't have anything available to me. The only other part of that would have been that when I did initially speak to her, she did tell me that she had consumed alcohol hours prior. But other than that, and outside of the field testing, no.
No further questions, Your Honor.
Judge, despite a vague allusion to the collective knowledge doctrine, absolutely no competent evidence has been presented to this court that can establish by a preponderance of the evidence that the stop of Ms. Thomas was justified based on reasonable suspicion. Hearsay has no probative value, Judge. My understanding, I'm doing a brief, as this motion's going on, understanding of the collective knowledge doctrine, but my understanding is that it may allow officers, well, it does not apply to overcome the hearsay ban and allow hearsay statements to establish reasonable suspicion for a stop without anything further, Judge. In this case, if so, the defendant has been denied the ability to cross-examine the officer who provided this information. So therefore, that would be a due process violation. There has been no testimony about any traffic violations, just that basically that was told to him by another officer. The state has the burden to present evidence, and they have the burden to present evidence that can convince you by a preponderance of the evidence that the stop on Ms. Thomas was lawful. If not, any evidence that was obtained after the stop is fruit of the poisonous tree and subject to the exclusionary rule. Here, Judge, I don't know how many times, Judge, there has been no evidence, none. A reference to the collective knowledge document does not establish a fact by a preponderance of the evidence. Hearsay has no probative value. Judge, we're asking that all evidence against Ms. Thomas be suppressed, as the state has failed to present any evidence whatsoever that is competent that this court can rely upon to establish that Ms. Thomas was indeed lawfully pulled over. Her rights under the Fourth Amendment, of the Constitution, and under Georgia, she has, and under, OCGA 17-5-30, she does have the right to be free from illegal stops in the state. Again, has the burden to establish that the stop was based on reasonable suspicion. They have failed to do that. Judge, I'm asking that all the evidence against, or any evidence that flowed from this illegal detention of Ms. Thomas be suppressed. Thank you.
Oh, I'm sorry. Yeah, Honor. The defense's argument focuses on the reasonableness of the stop, arguing that the officer that testified today did not personally observe a traffic violation and that the stop was unlawful, but that is not, I think that's a mischaracterization. Under the collective knowledge doctrine, which we referenced a couple of times today, reasonable suspicion can be based on the information that was relayed from another officer who actually did directly observe the violation. The officer that observed the violation did observe a traffic violation and then asked for subsequent officer communicated to other officers and asked for other officers to respond, which formed the basis for the testifying officer, the officer that testified today, to be on scene. The fact that he simply arrived later and the fact that he did not personally observe the violation, that more so goes to his role in the investigation, which is why he completed the subsequent DUI investigation, and not. It doesn't go as much to the legality of the stop itself. The stop was supported by reasonable suspicion, reasonable articulated suspicion based on the officer's own firsthand observations that he relayed to the unit. And therefore, I believe that the testimony hearsay at all. And I do believe that this witness's testimony does not negate the validity of the stop. And we do respectfully request that Your Honor deny the motion to suppress on that basis.
So we've talked a lot about the collective knowledge doctrine, but there are some limitations to it. So the purpose of the doctrine is to allow judges to hear the information necessary to make a decision that has a bearing prior to trial. So to make the decision based on whether information should be suppressed from the trial, the judge needs to hear it in a condensed version, and we're not putting on an entire trial. Thus, the collective knowledge doctrine. But the limitation is that in order to establish reasonable, articulable suspicion or probable cause, the officer speaking and relaying the collective knowledge has to have some basis independent of his information from other officers or other sources that would be the basis for reasonable, articulable suspicion or probable cause. In this case, as the testimony was given, this officer was told, was dispatched to the scene based on the request for assistance from a deputy. At the scene, he was told by the deputy that the deputy saw this individual leave their lane and jerk back into the lane, and that he smelled an odor of alcohol. What this officer then did was make contact with the individual, and on the basis of a slight odor of alcohol, and as we know, it is not illegal to imbibe alcoholic beverage and drive, based on a slight odor of alcohol, which absent the hearsay testimony or the collective knowledge testimony from the deputy, there would have been no way he could have appreciated the slight odor of alcohol such that it would have formed the basis of reasonable, articulable suspicion for the stop in this case. Anything after that is based on the hearsay and not on this officer's actual ability to determine that there was a reason for the stop and that there was probable cause for everything that followed. And so the court finds that this motion to suppress should be granted, not because this officer didn't do the job he was supposed to do, but because when he came, by the time that he came into the investigation, the parts that would have established the reasonable, articulable suspicion to stop and initiate the investigation had been done by another officer who is not here to testify, and his testimony is only entered into the record of the court based on the collective knowledge doctrine. And based on the collective knowledge doctrine, that testimony is insufficient to establish reasonable, articulable suspicion. It is hearsay without another officer having observed it and having testified to what he observed. So this court is going to grant the motion to suppress. Give me an order, Mr. Lynch.
Judge, you'll have it by the end of the day tomorrow.
All righty. All right. Do we have anything else?
That's my vote.
Not that I'm aware.
All right. I will be signing.
Thank you, Judge.
A lot of stuff.